Hello everyone and welcome back to the channel. Hope you're all keeping well, and welcome to chapter 4 of this series on the criminal litigation element of the bar course. So just a reminder, we're looking at Blackstones syllabus 2025, which is accurate at the time of recording, and this is just a general overview on the topics covered on the course. So it's not meant to be an exhaustive and detailed revision session, but just as an insight into the different areas, and also a general audience can also follow if interested. So today we're breaking down one of the most important decisions made at a first hearing, and that's bail. This single question can decide whether someone walks out of court through the front doors or leaves through the tunnel to a cell beneath the building. So by the end of this episode, you'll understand when someone can be refused bail, why the law presumes bail, and how judges balance public protection, fairness, and liberty. Before we get stuck in, just thanks to everyone who's subscribed so far. It does really help to expand the channel and increase the scope of the videos that we can produce. So thank you for everyone who has subscribed. If you haven't, if you do enjoy the content, certainly just do like and subscribe, and it's most grateful. So bail in England and Wales is governed by the Bail Act 1976, and this is supported by the criminal procedure rules, and this is shaped by Article 5 of the European Convention on Human Rights, which is the right to liberty, so free movement and not being locked up, so to speak. So the rules are clear. Bail is the starting point, and if the state wants to restrict liberty, it has to justify it properly. So let's begin with that starting presumption then. So every first hearing, especially in the magistrate's court, the court must start with a presumption in favour of bail. So the basic default is that bail will be granted unless circumstances dictate otherwise. And that comes straight from the Bail Act 1976. The idea is simple. In a free society, people should not be locked up before trial unless there are genuine legal reasons. So when can bail actually be refused then, you might be thinking? Well, the court can refuse bail only on specific grounds, not on instinct and not on emotion. Under Schedule 1 of the Bail Act, the question is whether there are substantial grounds to believe the defendant would either fail to surrender, commit further offences, and or interfere with witnesses or justice. So if their answer is no, bail should be granted. If the answer is yes, the court must explain why. And this is where, if you are looking for a career in the law, specifically a barrister, early on in your training and in your practice, you will take on a lot of these bail hearings. If you're acting for the prosecution, you'd be looking to trying to remand the defendant in custody, whereas if you're a defending counsel, you'd be looking to grant bail. So counter arguments, both sides. So what do those grounds actually look like in the real world? Fail to surrender. So that's someone who's likely to disappear and not attend the trial at all. There could be a flight risk as well and just disappear. Further offences, that's a genuine risk of re-offending while on bail, and that could be similar offences or other offences. And interference, that's threatening witnesses, destroying evidence, or undermining justice overall. This specifically, mainly it does happen where there's one victim and the accused can potentially approach that person or look at the evidence and disrupt justice. So these are public protection tests, they're not punishment, so to speak. So before refusing bail, the court must look at alternatives to custody, things like curfews or residence requirements, reporting to police, electronic monitoring or tagging, non-contact orders, or even surrendering their passport. So in other words, conditions before remand. And this is where the defence lawyer will try to mitigate and secure bail, maybe conceding a few of these conditions. If a condition can control the risk, custody should not be used. If someone is kept in custody, the clock starts. So custody time limits, or CTLs, ensure the state does not lock up people and drag its feet. The prosecution must act with due diligence, and if the time limit expires, the defendant must be released on bail. That's the safeguard. You can imagine if a person who is actually not guilty eventually and has spent a significant period of time remanded prior to trial, that could be deemed an injustice for that individual. They could feel very aggrieved. If bail is refused, the defence cannot just rerun the same arguments. A repeat application needs new information or a change in circumstances to challenge the first direction. Otherwise, it'll be refused as an abuse of process. So Article 5 reminds the court that the detention must be necessary, proportionate, and exceptional. Judges must justify it with relevant and sufficient reasons, and always consider less intrusive measures first. Remember the European Court of Human Rights, liberty is the default, custody is the exception, and not the other way around. So what about a youth? So where a child or vulnerable adult is involved, the court must take extra care, considering additional factors such as welfare, safeguarding, support, and youth offending team input. The criminal process should protect the vulnerable, not compound their difficulties. So it's just another element to consider for a vulnerable adult or a minor. And what about appeals then? So bail decisions are not final. The defence can apply to vary. The prosecution can appeal the grant of bail, especially under the Bail Amendment Act 1993. But whatever the outcome, the court must record its reasons, so the decision is transparent and accountable. So that's the principles of bail. Principles are simple. Bail is presumed, refusal must be justified, and conditions come before custody. That's how the system protects both liberty and public safety. Hopefully that was a good overview for you. It's just a brief snapshot, as I said earlier. But on the basis of that, do you think the balance is right, or is the system too strict or too soft? Drop your thoughts in the comments below. Also, if you do have any further questions about the content in particular, drop a comment. But if you did find this useful, hit subscribe and like, and join me for the next episode where we're going to look at disclosure and case management, chapter 5, where we'll break down how evidence is shared and how cases are prepared for when it comes to trial. But I hope you enjoyed that video. Thank you for watching. Hope to see you on the next video, and it's bye-bye for now.